Rap superstar Lil Durk locked up right now, accused of ordering a hit on a rival rapper, but his defense says the government's only proof that Durk was involved is based on a random video they found on YouTube. And now they brought in music producers who've worked with Durk, and it might just blow up the whole case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Did Chicago rapper Durk Banks, also known as Lil Durk, orchestrate a murder-for-hire plot against Quando Rondo that ended with the rival's cousin dead and multiple people caught up in the conspiracy? Well, that's what the government's alleging, and they point to Durk's own song lyrics as proof of his alleged actions. That's what we want to focus on, because the defense says there is a big problem with that Durk recorded those lyrics months before the alleged murder for hire. And unless he had a time machine or he could predict the future, there's really no way they could be about this killing, about this alleged murder. So Durk's team has filed a motion to dismiss the federal indictment against him, or at the very least, release information about what the government showed the grand jury to support the charges in this case. The motion reads, quote, "Defendant Durk Banks, through his counsel of record, moves the court to dismiss the superseding indictment against him in this matter. In the alternative, he moves to compel disclosure of the grand jury minutes and evidence the government presented to the grand jury." Now, before we dive into the juicy details into this filing, I do want to give you just a quick history on how we got here, in case you're not familiar with it. So, after the death of his friend King Von back in 2020, Durk reportedly put out a hit on Quando Rondo, a rival rapper in Georgia that Durk allegedly believed was the instigator behind his friend being killed. So prosecutors say in 2022, Durk found out that Rondo was going to be in Los Angeles. So he allegedly organized members of his crew, a rap collective called Only the Family, or OTF, to travel to Southern California and target Rondo. And the government claims that OTF is a criminal enterprise that has engaged in violence, including murder and assault. Investigators believe that Durk's right-hand man, Kevon Grant, was the one who secured the cars, the hotel rooms, and the guns for this assassination of Rondo. An October 2024 indictment accused multiple defendants of following Quando Rondo's black Escalade around LA on August 19, 2022. In fact, traffic camera photos show a white Infiniti following the SUV until it pulls into a gas station. And the filing also apparently includes surveillance photos of the suspects appearing to fire guns toward the gas pumps. Yeah, not a great idea. At least 18 rounds were fired at the car in broad daylight, including, apparently, a machine gun. Remember, during a busy afternoon at a gas station. This is a blatant attack. Now, Quando Rondo actually wasn't hurt in the shooting, but it turns out, in a sad turn of events, his cousin, Savannah Robinson, referred to as SR in court documents, was killed. When the indictment against several people, including Kevon Grant, came down in federal court, Durk wasn't even named as a defendant yet. Rather, he was an alleged collaborator identified as co-conspirator 1. However, in a superseding indictment a few weeks later, that is when Durk was added officially as a named defendant and was charged with conspiracy and use of interstate facilities to commit murder for hire resulting in death, and use, carry, and discharge of firearms and a machine gun in furtherance of a crime of violence resulting in death. And while Durk isn't actually accused of being at the Beverly Hills gas station when this apparent shooting happened, prosecutors say he was the one who called for the hit. He was the one who ordered it. He helped facilitate travel to Los Angeles, and he paid the men who actually did the shooting. Prosecutors allege that Durk texted a co-conspirator, "Don't book no flights under no names involved with me." But since that time, Durk offered a substantial bail package to get pretrial detention. The judge denied it. He has maintained his innocence, and now his lawyers are arguing this whole case against him needs to be tossed out. And it all relates back to rap lyrics sung by Durk as a feature on a song by another artist, Babyface Ray. And the prosecution claims that Durk rapped about Savannah Robinson's death, commercializing his alleged revenge. So here are the lyrics that the prosecution is talking about. Quote, "Told me they got an Addy, go, go. Got location, go, go. Green light, go, 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 go. Look on the news and see your son, you screaming no, no." Now, prosecutors seem to claim that the no, no part comes from when Quando Rondo was apparently screaming no, no when his cousin was shot. And they reference how the song allegedly has audio of Rondo screaming that, reportedly taken from news footage. But the defense says that couldn't be farther from the truth. All right, so to talk about this, I want to bring on civil rights attorney Joe Richardson, who I'm so happy to see. I haven't seen Joe in quite some time. So, Joe, thanks so much for taking the time to come back here on Sidebar. Look at that face. Always smiling, always happy to be on.
Good to see you,
and
Jesse.
I'm happy to talk to you about this because this has been a hot topic over the last couple of years. Can prosecutors take what's said in rap lyrics, in song lyrics, and use it as a kind of confession? Generally speaking, I mean, how does it work? Have we seen it a lot in trials? Has it been persuasive?
We've seen it happen quite a bit. I don't know that I'd say it's been persuasive. I think the biggest example we look at is Young Thug down in Atlanta. They took a lot of his lyrics, and even though technically speaking, ultimately they got a conviction, he actually walked out on time served. Most of the people that were prosecuted didn't end up being convicted. And I don't think anybody would call that prosecution a successful prosecution. And so, you've got freedom of speech issues. Does it mean that just because I'm saying something in a rap song, it typically is a rap song, does that mean that I actually did something? And this is an extra interesting twist here because Lil Durk's attorney is saying, well, this song was actually released months before the murder. So he can't say in the past tense that I did something that I hadn't done that hadn't happened several months before. So we're seeing it more and more. I don't know if I'd say it's successful, but it's interesting that they've used this to get a superseding indictment.
Talking legal issues like this, how can I not bring up legal experts, our sponsor, our partner, Morgan & Morgan, America's largest injury law firm. You know why they're so large? Listen to this. Past few months, Morgan & Morgan secured a $9.3 million verdict for a car crash victim in Florida, $5.6 million verdict for another car accident victim in Atlanta, and not to mention $1.8 million in Kentucky after insurance offered them a mere $5,000 in that case. And look, even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. You don't even have to leave your couch. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar or click the link in the description and pinned in the comments. Do you know how they typically authenticated a trial? I mean, who do they call to the stand in order to get the lyrics in and say it is what it is? Do you know? I'm just trying to imagine how this might come up at an upcoming federal trial.
Well, there's a couple things, right? First of all, is there actually a reasonable denial that person can make that they actually got on and did the lyrics, right? So it's going to be somebody, I would imagine, from an authentication purpose, somebody that was in the studio, frankly, somebody that they're squeezing that they might know and hear. You've got co-conspirators that have been indicted as well. So it's going to be somebody that was there, as it were, because all other things being equal, Lil Durk's not going to get on the stand and testify against himself because most times people don't. So you're going to authenticate it in kind of regular ways. Someone that would have cause to know that these were the lyrics that were made. Now, it's a separate issue entirely as to whether or not you can authenticate or confirm this is what the lyrics were about. This is what they were talking about. Here's the backdrop, and all of those other things become subject to cross-examination, et cetera.
So I want to dive into this motion to dismiss and get into the meat of it. So it reads, quote, "The government presented false evidence to the grand jury that indicted Mr. Banks on November 7th, 2024. The plain language of the superseding indictment makes it apparent that the government told the grand jury that Mr. Banks, through specific lyrics in his music, celebrated and profited from a revenge murder that he had ordered, namely that of SR in August of 2022. That claim is demonstrably false. The song the government relied upon as evidence against Mr. Banks, Wonderful Wayne and Jackie Boy, a song that was recorded by another artist, Babyface Ray, and in which Mr. Banks recorded a feature for, could not have been a commercialization of Mr. Banks' alleged murder for hire of SR as the government represented to the grand jury. That is because Mr. Banks recorded the lyrics for Wonderful Wayne 7 months before the incident even happened. The government's misrepresentation in the superseding indictment, whether knowing or reckless, undermines the integrity of the grand jury's true bill against Mr. Banks. The court should dismiss the superseding indictment against him as a result. Now, the defense argues that the court has the power to dismiss an indictment that the grand jury returned based on information that the government knew at the time to be or later learned to have been false. Joe, so you got to have a good foundation here, right? Talk to me about that argument, because I guess the counter argument would be, well, in the end, based on the prosecution's allegations, he did exactly what he rapped about. So it's, maybe it's not necessarily predicting the future. He maybe anticipated what was going to happen and did it.
I think that if I'm the defense, I'm going to focus on the misrepresentation, assuming there was a misrepresentation. Right now, it's a horse of another color. To your second point, if in fact the timing of the lyrics was not important and wasn't presented as such to the grand jury. Grand jury typically has a low standard, right? You just need to show probable cause to show that a crime has taken place, and then you get held over for trial. However, if they made a representation or suggested that those lyrics and that song came out after the murder and it talked about something in the past tense that had happened, I think that the defense is strong standing on the foundation and saying, you've made a misrepresentation of the evidence, and fundamentally, this thing is sitting on a shaky foundation, and it can't go forward based on the presentation that you've made.
Let me ask you that. If there is even one piece of evidence that's presented to a grand jury that's problematic, does that mean the indictment has to be thrown out? Could the court look at that and say, listen, we don't know if that was the reason the grand jury returned their indictment? It might have been a small piece, but what about all the other evidence they presented? Or is the argument, if you presented one piece of evidence that either was, intentionally or recklessly shown, that was presented that turned out to be false or inaccurate, is there grounds to throw it out?
Yeah, that's a good question. The standard is low, right? And so the prosecution is not necessarily going to be penalized for every small error or for every imperfection, as it were. Okay. So perhaps it could still survive with the judge saying, well, we don't know if that's the actual reason that they did it. However, the problem that they have here is he apparently was central because the superseding indictment makes him a defendant. And before, he wasn't a defendant. He's graduated from not being a defendant to being a defendant. So how is it that this particular piece of evidence isn't key and isn't fundamental? And so, of course, if I'm the defense, that's what I would be saying.
By the way, I didn't mention this. There's a First Amendment argument here, right? That this violates the First Amendment. Can you talk about that?
Right, for sure. I mean, I'm expressing myself. I can say the things that I want to say in a rap record or any kind of record. And you could go back and there's country records and there are pop records and there are R&B records that talk about all kinds of things. It's just that there's this notion that with hip hop, quote, glorifying violence, that suddenly now we're going to use these things to prosecute them. But does that mean that the free speech, the First Amendment has gone away? No, absolutely not. He can absolutely rap about what he wants to rap about. And that doesn't mean just because the story is violent, just because a Tupac story is violent, just because a Biggie Smalls story is violent, that doesn't mean that ought to be used to in turn put together the cogs to actually criminally prosecute someone, because there is still free speech.
Now, the counter argument would be, it's a statement. It's a statement that, is relevant. It's on point with the actual issue, the case. How can we not be able to use it same way? If somebody does an interview, like I'm talking about the Karen Reed case, right? She does an interview. Yes, it's a media interview, but technically can be used against you. What you say can be used against you. Let me ask you this, though, about it. If the government was wrong, okay? If the government didn't realize the time frame of it, or even now, they suggest that, it was a problem, we shouldn't have included it. How could they make that mistake, assuming it was a mistake or an error in some fashion? I mean, doesn't that show a potential weakness in the prosecution overall? I'm not saying that's what they're arguing. I'm not saying that's where this is going to go. But if you take the defense's argument as true, that would be a big slip up for the prosecution, no?
Yeah, and I'll go out on a limb and say that sometimes prosecutors don't necessarily understand hip hop culture. It's almost like a text without context. So you got to really understand the time, the place, the audience. Sometimes they might speak in ways that seem direct to somebody that's outside of the culture, but doesn't necessarily, but can mean several things to someone inside the culture. So it would certainly be a flub big time, right? But it wouldn't be the first time that such a thing has happened where somebody looking through the window, particularly of hip hop culture, doesn't understand what's being said other than their desired use of it, right? And so maybe that's a situation. It shouldn't be. Listen, there's got to be a prosecutor back there that's got the context that knows what's going on in the street. They prosecute folks that are in hip hop culture that aren't necessarily rappers. They prosecute folks that are, accused of being drug dealers, this or that and the other, or in gangs or whatever it may be. And as part of that is understanding the language, understanding what someone means when they say something, understanding manner and timing and all those other things. That's part of their job. The mob speaks in a certain language too. In order to successfully prosecute him, you got to understand the language. So there might be reasons for them screwing that up, but there wouldn't be excuses.
So the defense motion continues, actually. I want to get more into it. It says, quote, the indictment's assertion about Mr. Banks' lyrics, their timing and their meaning is false. When Banks wrote the cited lyrics, SR's killing was still 7 months in the future. For Banks to have been writing about SR would thus have been impossible. The only open question is how such patently false information came to be within the grand jury's purview to begin with. One answer is that the prosecutors who prepared and presented the government's evidence knew that the evidence was false. Another is that the prosecutor who presented the evidence did not know it to be false, but the witness who conveyed it did. And the third answer is that the evidence was obtained and presented with reckless disregard for patent falsity. As explained further below, regardless of the answer, dismissal is warranted. And that actually brings now the defense to their next argument to the judge, which is, quote, if the court is uncertain whether the false information that the government presented to the grand jury requires dismissal, the court should order the government to produce the transcripts and evidence from the grand jury proceedings. Now, Joe, we'll get into this argument a little bit more, but generally speaking, I know under the federal rules a court may authorize disclosure of grand jury matters if the defense asks pursuant to a motion to dismiss. I just wonder how often is that request successful to get that material? Because grand jury material is secret, generally speaking, right?
Right. It generally is, and you want to preserve the integrity of the grand jury, but it's almost grand jury is kind of like this secret thing, and we go and we're not telling you what we're mixing up and what we're putting together, but we produce an indictment, right? But I would argue that this particular notion, this particular set of circumstances, would justify revealing the information from the grand jury transcript because it's directly on point to the presentation that the prosecution made in order to get the indictment. And so it is unusual because you want to preserve the integrity of grand jury proceedings. Grand juries are carried out a certain way for a certain reason. But that being said, in a situation like this, where you could potentially have something go on that's demonstrably false, and you actually make it from not having an indictment to an indictment based on false information that may have been presented falsely, maybe knowingly, and certainly recklessly, at least, I think you need to know about it.
Now, let me continue with the defense's argument here, Joe. So they say, quote, the problem with these productions, however, is that Mr. Banks did not create these videos, and the government has failed to show any nexus between these manufactured video clips and Mr. Banks. These videos were not created nor posted at Mr. Banks' direction. The internet users who posted the videos, including at OTF Edit and at My Mixtapes, are apparent fan pages maintained by people with no affiliation to Mr. Banks or Only the Family, Inc. The court should order production of the grand jury transcripts to clarify whether in charging Mr. Banks, the grand jury erroneously attributed these or other fan page edits to Mr. Banks, as the government has clearly done. And to bolster that argument, the defense included sworn statements from two producers who worked with Banks on this song and other projects. First, You have Justin Gibson, also known as Just Vibes. So he's a producer and sound engineer who says that he had been working with Lil Durk since 2021. And in his statement, he writes, on January 25th, 2022, I had a recording session with Mr. Banks where we recorded the song Wonderful Wayne and Jackie Boy, which at the time we called Too Toxic. I loaded the song up around 5:39 p.m. Mr. Banks then wrote the verse right there in the studio, and we recorded the song and finished in less than an hour. Once we recorded the song, I bounced out a rough draft, saved a copy in audio format, and named it Toxic Babyface featuring Lil Durk at 6:33 p.m. After that, we continued with the rest of the session. And now remember, the shooting at the California gas station happened months later on August 19, 2022. So the motion includes a second sworn statement, this one from a music producer and audio engineer named Ahmad Sharif. He says, I received Durk Banks' verse and lyrics for Wonderful Wayne and Jackie Boy from Justin Gibson on July 22nd, 2022, so the month before. After July 22nd, 2022, I received no other additional lyrics or modifications to the original lyrics from Durk or anyone in Durk's camp. And Sheriff then talks about the apparent edits to the song, which includes Quando Rondo screaming, no, no. I have reviewed certain YouTube links concerning the song Wonderful Wayne and Jackie Boy. As a producer and audio engineer who worked on Wonderful Wayne and Jackie Boy, I can confirm that the audio and video clips featuring audio of an individual yelling no, reportedly from a news clip, are not from the original recording. These clips appear to be fan edits, specifically for social media platforms such as TikTok, and are altered, fabricated, and inauthentic versions of the song. Joe, it's a pretty good argument from the defense. Again, if that's true, prosecution didn't figure that out?
Yeah, and you don't even know whether or not what you used actually came from the artist. That's one of the big points that they're making here, is that there were things that were edited later, and that's why it's so much more important for us to understand what the presentation actually was to the grand jury, because demonstrably we could actually probably show that this is something that came from a fan's edit as opposed to what Lil Durk actually did in the studio. So yeah, so there's another reason there that this has ended up being a problem.
Now, I will tell you, I mean, in today's day and age, it's hard to know what's authentic. I see a movie trailer, it looks like the real thing. It was a fan page. AI? Right. Oh my gosh. You think this is going to be the end of the problem? Now, in the conclusion of this filing, the defense says, a prosecutor who knowingly secures an indictment based upon false information or who allows a falsely obtained indictment to persist routs the grand jury from its central protective function. That is clearly what happened here. For the foregoing reasons, the court should dismiss the superseding indictment against Mr. Banks. In the alternative, the court should compel disclosure of the relevant underlying grand jury proceedings. Joe, how's this going to shake out? You think the court is going to agree, dismiss the indictment? Could they refile it without the lyrics? Do you think the prosecution is going to fight back at it? Because I'll tell you, at last check, we checked the federal court records, and as of this recording on Tuesday morning, neither the judge nor the prosecution has responded to this motion to dismiss. So how's this going to all shake out in the end?
I would think that the defense is going to get one or the other, one being either dismissal of the indictment or a compelling of a review of the transcript so that they can know. I mean, they've got some pretty good notions. Those declarations under penalty of perjury, of course, would tend to suggest very strongly that what came out and what they are using is not, it happened, was done many months prior to the actual killing, and that it might be even in a different form what Lil Durk actually did versus what was actually released and possibly used. Under those circumstances, I think you gotta do something so that you preserve the integrity of the grand jury process. So the defense is hoping for that. In a case like this, based on these particular facts, I think one or the other ought to happen.
Joe Richardson, man, I love having you on. Thank you so much for taking the time. It was great seeing you, and we'll see what happens next.
It's going to be crazy. Thanks much, Jesse. You guys be good.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.